Welcome to Part 2 of Chapter 15, Release of the Accused Prior to Trial, Judicial Interim Release. So, remember in the first recording we looked at the reasons and the situations when someone who is detained by the police, why they are released prior to their trial. Now this covers a situation where someone is actually arrested and spends the evening in jail, and how do they get out pending their trial. So judicial interim release is what you and I all know as bail. Section 503 of your criminal code says, within 24 hours of arrest, or ASAP, as soon as possible, which might be what we're going through right now, police must bring the accused before a justice for a bail hearing, also called a show cause hearing. So, judicial interim release, bail hearing, show cause hearing all mean the same thing. So, just keep that in mind. Why do we have a bail hearing or a show cause hearing? What's its purpose and process? Section 518. Justice may admit evidence that would normally be inadmissible if it's credible and trustworthy in these circumstances. So the amount of or the type of evidence that comes in during a bail hearing is going to be slightly different and perhaps a little bit more generous than under a normal trial. And the prosecution is not allowed to use the bail hearing to examine, question, ask the accused about the offense. So this hearing is not really about the offense, although I guess it kind of is. It's about whether the accused should spend time amongst the rest of us pending trial, or needs to stay in jail until trial happens. So let's look at this process in terms of what happens in what we call a regular bail situation. The onus is on the Crown. So remember, the Crown is the Crown prosecutor. This is the lawyer that works for the government, to show why the accused should not be released. Why do they need to stay behind bars, essentially? The accused may be held if the Crown proves one of the following on the balance of probabilities. Now, this is a little different than when we go to trial. Trial is beyond a reasonable doubt, which I kind of think is, remember, that's 95% likely to have happened. Balance of probabilities is prove it 50% or so, or 50% or better. So Crown needs to prove 50% or more that the accused is unlikely to appear for further court appearances and trial. That's the primary ground. The Crown needs to show that the accused is here because we kept them in jail overnight, but they're not going to show up again. And so 50% or more that they're not actually going to show up. 2, the accused poses a risk to the public safety, including victims and witnesses, and that is your secondary ground. And then there's a tertiary or third one. Confidence in the administration of justice will suffer if accused is released. So taking a look at these again, primary grounds, how is the accused tied to the community? Do they have family, friends, work that's going to make them stay here and show up? Do they have a previous criminal record? Looking about the risk to public safety, or secondary ground. The seriousness of the alleged offense. Again, the accused criminal record, and are they a danger to victims or witnesses? And the third ground, the tertiary ground, so what's the seriousness of the offense? It's the circumstances surrounding the commission of the offense. Were firearms used? So kind of the way I look at this, kind of the tertiary, what's the public going to think? Maybe. So remember, the Crown has to show why the accused should stay in jail, because they're not going to show up. You and I as the public are at risk, or somehow the administration of justice will suffer. So the image of justice will suffer, and that's why they should stay in jail. And the Crown has to prove this. The accused doesn't have to prove anything. So the Crown's going to have to do a little background digging with respect to those and which one applies. So our regular bail situations continued. If no grounds exist for detaining the accused, they can't make a case on the primary, the secondary, or tertiary. The accused will be released on an undertaking without conditions, or release conditions may apply. So, conditions. This restrictions on the release of the accused, what they can and cannot do. So undertaking with conditions, recognizance without sureties, recognizance with sureties without a deposit of money, recognizance without sureties with a deposit of money. Sureties, the definitions and requirements. Who is a surety? A surety is a person who agrees to supervise the accused, ensure the accused attends court, obeys any conditions, and the definition of this is on page 173 of your textbook. So if you take a quick look at page 173, that's where you will get, no, that's not page 173. Show cause hearing. A surety. It's on page 184. It's defined in the margin of your textbook. So the surety, or this person, must be an adult that does not have a criminal record. And some of the conditions that can be placed. So let's looking at these in a little bit more detail, or a couple of other comments. So an undertaking with conditions. So the accused promises to do or not to do something. Recognizance without sureties. Again, that is an example of promises. Recognizance with a surety, so someone who's going to make sure the accused shows up without money. Recognizance, so a promise to appear without sureties, so without a person, but with a deposit of money. So either you're going to have someone step forward and say, hey, I'll make sure they show up, or we're going to put some money saying, yes, they'll show up. So different ways to look at that. And some examples of actual conditions that might be placed are found on page 184 of your textbook. Things like deposit your passport with the courts, obtain from going to a specified location, abstain from alcohol or other intoxicants, especially if the substances were involved in the offense. So there's a few others that are listed on the bottom half of page 184 of your textbook in the bullets that are there. So in a regular bail situation, the Crown has to prove why the accused shouldn't be released, because they're not going to show up. Their risk to a public or the administration of justice is put into possible looking worse than it is. And the accused, if they are released, just to promise to appear, recognizance with someone else, the surety saying, yeah, I'll make them show up. The recognizance without a surety, so no person, with money being put forward. So those are some of the outcomes if the Crown is not successful in convincing the judge that the accused should remain behind bars. So there is something called a reverse onus situation. It is set out in section 515(6). In certain circumstances, for certain offenses, the onus is on the defense, so the accused lawyer, to prove on a balance of probabilities, more than 50%, that the accused should not be detained while awaiting trial. This happens when the accused is charged with an indictable offense while on bail for another indictable offense. So they got out on bail, didn't take it seriously, and they went and broke the criminal code or did something illegal again. Remember what I said, criminals always aren't the smartest. This would be an example. Certain offenses, so for example, organized crime, terrorism, trafficking of firearms or weapons, and some weapons offenses. The accused has to prove why they should be released. A non-Canadian citizen charged with an indictable offense or more serious offenses. Accused charged with failing to appear or breach of bail conditions, so they were given a summons to appear and they didn't, or they were released on bail and, for example, they were supposed to stay away from a specific location and they didn't do that. The accused is charged with a CDSA offense, Controlled Drugs and Substances Act offense, that carries life imprisonment. So, there are times the accused has to show why they shouldn't stay behind jail if they've done one of those 5 things, or they fall into one of those 5 categories. So sometimes the accused has to do some work, or the accused lawyer. Section 469 offenses. Most serious offenses in the code, murder and treason are a couple of examples. And oddly enough, or maybe reasonably enough, there's no automatic entitlement to bail hearings for these offenses. The accused must apply for release under Section 522 bail hearing, and if granted, must take place before a superior court judge. So in Alberta, that's a Court of Queen's Bench judge. And on these ones, the onus is on the accused to show cause why he or she should not be detained. If the application is successful, the court may release the accused on an undertaking or a recognizance and attach conditions to release. So take a look at sections 515.4 and 4.1 and 4.2. So what we often see at bail hearings and going forward is not only in addition to requesting bail or reasoning why bail shouldn't be granted, one of the first things that's often dealt with is also publication ban. So that prohibits the media from publishing, broadcasting information about a case for a specific time, and often it's the accused that asks for this. Section 517 of the code requires courts to comply with ban requests by accused persons. Evidence taken, information given, representations made, and justice's reasons for decision about bail may not be broadcast. The Supreme Court has said that Section 517 does violate Section 2B of the Charter. That's our freedom of expression, but it's saved under Section 1. So someone might have the right to express their opinion, but it's justifiable in the circumstances because we want to give somebody a fair hearing. So you can kind of see why that would happen. So when somebody is arrested, remember, they haven't been found guilty. They're still innocent. So can we postpone or adjourn a bail hearing? Yep. So there is an exception to Section 503 that a bail hearing must occur within 24 hours of arrest or as soon as possible. The Crown or the defense can request an adjournment of up to maximum of 3 days, unless the accused is okay with waiting longer for whatever reason. Why might we adjourn? Defense needs more time to prepare, gather info, investigate availability of a surety. Remember, the surety is a person to make sure that the accused does what they're supposed to. And when there's a concern that the accused may not be released, defense must investigate restrictive conditions that can be applied to encourage release. So put some fairly serious conditions on the accused. So if someone is denied bail, bail can be reviewed, or at any time bail can be reviewed. Bail orders remain in effect until the end of trial unless amended after a bail review by a further court order. Section 520 does allow the challenge of bail denial conditions by the accused. Section 521, challenge of release order conditions by prosecutions. The prosecution's not happy with what the judge has put forward. Application must be made to a superior court judge and 2 days notice given to the other side prior to said request. The onus at this hearing brought by the accused is always on the accused, so they want the bail reviewed. It's the accused's job why they want the conditions or change or challenge of why they weren't given bail. And Section 525 timeframes for automatic bail review. And there actually is a Court of Queen's Bench form that goes along with this application process. And I will attempt to show you this document or stick that in our resources in D2L. That's it for Chapter 15.